In real estate transactions, a mortgagor generally may convey mortgaged property to a grantee unless the promissory note states otherwise. The grantee may take the property subject to the mortgage without becoming personally liable for the debt, or may assume the mortgage and become personally liable for the debt, with the mortgagor remaining liable as a surety. But what if the grantee who assumed the mortgage conveys the property to a second grantee, who assumes the mortgage? The Alaska Supreme Court considered this question in Swanson versus Krenik. In 1977, Thomas and Leila Krenik signed a promissory note in exchange for a loan with Alaska Federal Savings and Loan Association of Juneau. The note was secured by a deed of trust in favor of Alaska Federal on Krenik's property. Approximately 4 years later, the Kreniks conveyed the mortgaged property to Keith and Marie Swanson. The Swansons assumed the original note and deed of trust with Alaska Federal. The Swansons then executed a second deed of trust in favor of the Kreniks. In 1983, following Keith's death, Marie conveyed the property to Ray Rush and Howard Luther Jr. Rush and Luther assumed the original note and deed of trust with Alaska Federal. They also assumed the second deed of trust and executed a third deed of trust in favor of Swanson. Under the assumption agreement, the Kreniks, Swanson, Rush, and Luther were jointly and severally liable for the debt. But the agreement also explicitly stated that it didn't change the Kreniks and Swanson's liability on the original promissory note and deed of trust. Subsequently, Rush and Luther defaulted on their payments, and Alaska Federal brought a foreclosure action against the Kreniks, Swanson, Rush, and Luther in state superior court. In the action, Swanson filed a cross-claim against the Kreniks, arguing that the Kreniks were jointly liable for any deficiency judgment as co-sureties. The Kreniks also cross-claimed, contending that Swanson had a duty to indemnify them for any amount they had to pay to Alaska Federal. After the court granted foreclosure, the Kreniks and Swanson moved for summary judgment on their cross-claims, and the court ruled in favor of the Kreniks. Swanson appealed to the Alaska Supreme Court.